Persons and Family Relations Part 4. The Family. Under the Family Code of the Philippines. General Principles. The family as a basic social institution. Art 149. The family, being the foundation of the nation, is a basic social institution which public policy cherishes and protects. Consequently, family relations are governed by law, and no custom, practice, or agreement destructive of the family shall be recognized or given effect. Art 150. Family relations include those: 1. Between husband and wife. 2. Between parents and children. 3. Among other ascendants and descendants, and 4. Among brothers and sisters, whether of the full or half-blood. Effects on legal disputes. Earnest effort to compromise from suit between members of same family. Art 151. No suit between members of the same family shall prosper unless it should appear from the verified complaint or petition that earnest efforts toward a compromise have been made, but that the same have failed. If it is shown that no such efforts were in fact made, the same case must be dismissed. These rules shall not apply to cases which may not be the subject of compromise under the Civil Code. Article 2035, Civil Code. No compromise upon the following questions shall be valid. 1. The civil status of persons. 2. The validity of a marriage or a legal separation. 3. Any ground for legal separation. 4. Future support. 5. The jurisdiction of courts. 6. Future legitime. Case laws. Hontiveros v. RTC. The absence of the verification required in Art 151 does not affect the jurisdiction of the court over the subject matter of the complaint. The verification is merely a formal requirement. Moreover, as petitioners contend, Art 151 of the Family Code does not apply in this case since the suit is not exclusively among family members. Whenever a stranger is a party in a case involving family members, the requisite showing of earnest efforts to compromise is no longer mandatory. The inclusion of private respondent Asen as defendant and petitioner Maria Hontiveros as plaintiff takes the case out of the ambit of Art 151 of the Family Code. Martinez v. Martinez. A party's failure to comply with Article 151 of the Family Code before filing a complaint against a family member would render such complaint premature. Vayuda de Manalo v. CA. Art 222 of the Civil Code, now Art 151 of the Family Code, is applicable only to ordinary civil actions and not to special proceedings. Heirs of Favis, Sr. v. Gonzalez 2014. The base issue is whether or not the appellate court may dismiss the order of dismissal of the complaint for failure to allege therein that earnest efforts towards a compromise have been made. A failure to allege earnest but failed efforts at a compromise in a complaint among members of the same family is not a jurisdictional defect but merely a defect in the statement of a cause of action. The defect may however be waived by failing to make a seasonable objection in a motion to dismiss or answer, the defect being a mere procedural imperfection which does not affect the jurisdiction of the court. A. The family home. Art 152. The family home, constituted jointly by the husband and the wife or by an unmarried head of a family, is the dwelling house where they and their family reside, and the land on which it is situated. When is it deemed constituted? Art 153. The family home is deemed constituted on a house and lot from the time it is occupied as a family residence. From the time of its constitution and so long as any of its beneficiaries actually resides therein, the family home continues to be such and is exempt from execution, forced sale or attachment except as hereinafter provided and to the extent of the value allowed by law. Art 161. For purposes of availing of the benefits of a family home, a person may constitute, or be the beneficiary of, only one family home. Note: when is the effectivity of the Family Code? August 3, 1988. Family home must be principally residential. It includes both the land and the building. The occupancy of the family must be actual and not just merely constructive. They must actually live there, caretaker not allowed. Case laws. Modiquillo v. Briva. Is the family home of petitioner exempt from execution of the money judgment aforesaid? No. The debt or liability which was the basis of the judgment arose or was incurred at the time of the vehicular accident in 1976, and the money judgment arising therefrom was rendered by the appellate court in January 1988. Both preceded the effectivity of the Family Code on August 3, 1988. This case does not fall under the exemptions from execution provided in the Family Code. Beneficiaries of family home. Art 154. The beneficiaries of a family home are: 1. The husband and wife, or an unmarried person who is the head of a family, and 2. Their parents, ascendants, descendants, brothers and sisters, whether the relationship be legitimate or illegitimate, who are living in the family home and who depend upon the head of the family for legal support. Advantages of a family home is that it is exempt from execution, forced sale and attachment. Exceptions to the rule. Art 155. 1. For non-payment of taxes. 2. For debts incurred prior to the constitution of the family home. 3. For debts secured by mortgages on the premises before or after such constitution, and 4. For debts due to laborers, mechanics, architects, builders, material men and others who have rendered service or furnished material for the construction of the building. Limitations on the value of family home. Art 157. The actual value of the family home shall not exceed, at the time of its constitution, the amount of the 300,000 pesos in urban areas, and 200,000 pesos in rural areas, or such amounts as may hereafter be fixed by law. Disposition and encumbrance of a family home. Art 158. The family home may be sold, alienated, donated, assigned or encumbered by the owner or owners thereof with the written consent of a. the person constituting the same, b. the latter spouse, and a. c. majority of the beneficiaries of legal age. Continuance of the family home despite the death of the owner. Art 159. The family home shall continue despite the death of one or both spouses or of the unmarried head of the family for a period of 10 years or for as long as there is a minor beneficiary, and the heirs cannot partition the same unless the court finds compelling reasons therefor. This rule shall apply regardless of whoever owns the property or constituted the family home. Ramos v. Pangilinan. For family homes constructed after the effectivity of the Family Code, there is no need to constitute extrajudicially or judicially, and the exemption is effective from the time it was constituted and lasts as long as any of its beneficiaries under Art. 154 actually resides therein. Manicop v. Ca. The law explicitly provides that occupancy of the family home either by the owner thereof or by any of its beneficiaries must be actual. That which is actual is something real, or actually existing, as opposed to something merely possible, or to something which is presumptive or constructive. Actual occupancy, however, need not be by the owner of the house specifically. Rather, the property may be occupied by the beneficiaries enumerated by Article 154. This enumeration may include the in-laws where the family home is constituted jointly by the husband and wife. But the law definitely excludes maids and overseers. Patricio v. Dario 3. To be a beneficiary of the family home, 3 requisites must concur. 1. They must be among the relationships enumerated in Art 154 of the Family Code. 2. They live in the family home. 3. They are dependent for legal support upon the head of the family. Gomez v. Sta Ines. Marietta's liability, which was the basis of the judgment, arose long before the levied property was constituted as a family home by operation of law in August 1988. Thus, the liability incurred by Marietta falls squarely under one of the instances when a family home may be the subject of execution, forced sale, or attachment, as provided for by Article 155, particularly, to answer for debts incurred prior to the constitution of the family home. Paternity and Filiation. Legitimate children. A. Who are legitimate children? Art. 164. Children conceived or born during the marriage of the parents are legitimate. For a child conceived through artificial insemination to be considered legitimate, the following elements must concur. 1. Both spouses authorized it in writing. 2. If the husband had no knowledge, he ratifies later upon knowledge. 3. The instrument containing the agreement must be executed before the birth of the child. 4. The instrument shall be recorded in the civil registry together with the birth of the child. Art. 165. Children conceived and born outside a valid marriage are illegitimate, unless otherwise provided in this code. Art. 167. The child shall be considered legitimate although the mother may have declared against its legitimacy or may have been sentenced as an adulteress. B. Proof of filiation of legitimate children. Case laws. Gotardo v. Bueling 2012. One can prove filiation, either legitimate or illegitimate, through a. The record of birth appearing in the civil register or a final judgment. B. An admission of filiation in a public document or a private handwritten instrument and signed by the parent concerned, or C. The open and continuous possession of the status of a legitimate or illegitimate child, or D. Any other means allowed by the rules of court and special laws. 1. Primary proofs. A. Record of birth. B. Admission in a public document or a private handwritten instrument signed by the parent. 2. Secondary proofs. 1. Open and continuous possession of the status of a legitimate child. 2. Any other means allowed by the rules of court. Case laws. Versailles v. GSIS. The rule is that although the baptismal record of a natural child describes her as a child of the decedent, yet, if in the preparation of the record the decedent had no intervention, the baptismal record cannot be held to be a voluntary recognition of parentage. There is jurisprudence that a typewritten letter signed by the father is not an authentic writing. Kalimag v. Heirs of Macapas 2016. The petitioner's assertion that the birth certificate must be signed by the father in order to be a competent evidence of legitimate filiation does not find support in law and jurisprudence. Only in the registration of birth of an illegitimate child does the law require that the birth certificate be signed and sworn to jointly by the parents of the infant, or only by the mother if the father refuses to acknowledge the child. Aguilar v. Sayasat 2015. Alfredo Aguilar's SSS Form E1 satisfies the requirement for proof of filiation and relationship to the Aguilar spouses under Article 172 of the Family Code by itself. Said document constitutes an admission of legitimate filiation in a public document or a private handwritten instrument and signed by the parent concerned. Such due recognition in any authentic writing is, in itself, a consummated act of acknowledgement of the child, and no further court action is required. De la Cruz v. Garcia. 1. Where the private handwritten instrument is the lone piece of evidence submitted to prove filiation, there should be strict compliance with the requirement that the same must be signed by the acknowledging parent, and 2. Where the private handwritten instrument is accompanied by other relevant and competent evidence, it suffices that the claim of filiation therein be shown to have been made and handwritten by the acknowledging parent as it is merely corroborative of such other evidence. Mendoza v. Ca. Continuous. It does not mean that the concession of status shall continue forever but only that it shall not be of an intermittent character while it continues. There must be a showing of the permanent intention of the supposed father to consider the child as his own, by continuous and clear manifestation of paternal affection and care. Ong v. Ca. While Saturnina Cabal testified that she and Manuel Ong lived together for 4 months as husband and wife in order to justify a finding of cohabitation, the relationship was not open and public so as to constitute cohabitation. While the parties are not required to hold themselves out as husband and wife, neither must they act clandestinely or secretly, otherwise they will be considered to have merely engaged in illicit sexual intercourse. Rights of legitimate children. Art 174. Legitimate children shall have the right 1. To bear the surnames of the father and the mother, in conformity with the provisions of the Civil Code on surnames. 2. To receive support from their parents, their ascendants, and in proper cases, their brothers and sisters, in conformity with the provisions of this Code on support, and 3. To be entitled to the legitimate and other successional rights granted to them by the Civil Code. Grounds to impugn legitimacy. Art. 165. Legitimacy of a child may be impugned only on the following grounds. 1. That it was physically impossible for the husband to have sexual intercourse with his wife within the first 120 days of the 300 days which immediately preceded the birth of the child because of a. The physical incapacity of the husband to have sexual intercourse with his wife. B. The fact that the husband and wife were living separately in such a way that sexual intercourse was not possible, or C. Serious illness of the husband, which absolutely prevented sexual intercourse. 2. That it is proved that, for biological or other scientific reasons, the child could not have been that of the husband, except with regard to Article 164 paragraph 2, or 3. That in case of children conceived through artificial insemination, the written authorization or ratification of either parent was obtained through mistake, fraud, violence, intimidation, or undue influence. Art 168. If the marriage is terminated and the mother contracted another marriage within 300 days after such termination of the former marriage, these rules shall govern in the absence of proof to the contrary. 1. A child born before 180 days after the solemnization of the subsequent marriage is considered to have been conceived during the former marriage, provided it be born within 300 days after the termination of the former marriage. 2. A child born after 180 days following the celebration of the subsequent marriage is considered to have been conceived during such marriage, even though it be born within the 300 days after the termination of the former marriage. Art 169. The legitimacy or illegitimacy of a child born after 300 days following the termination of the marriage shall be proved by whoever alleges such legitimacy or illegitimacy. Case laws. Tan v. Trocio. Jewel Tan was born in 1972, during wedlock of complainant and her husband, and the presumption should be in favor of legitimacy unless physical access between the couple was impossible. From the evidence on hand, that presumption has not been overcome by adequate and convincing proof. Arbalario v. Ca. Once a valid marriage is established, it is deemed to continue until proof that it has been legally ended is presented. Thus, the mere cohabitation of the husband with another woman will not give rise to a presumption of legitimacy in favor of the children born of the second union, until and unless there be convincing proof that the first marriage had been lawfully terminated and the second, lawfully entered into. There is no presumption of legitimacy or illegitimacy in this jurisdiction, and whoever alleges the legitimacy or illegitimacy of a child born after the dissolution of a prior marriage or the separation of the spouses must introduce such evidence to prove his or her allegation. Undul v. Macarig. Impossibility of access by husband to wife would include 1. Absence during the initial period of conception. 2. Impotence which is patent, continuing and incurable, and 3. Imprisonment, unless it can be shown that cohabitation took place through corrupt violation of prison regulations. Experience shows that tuberculosis does not prevent carnal intercourse. Augustine v. Ca. Even if the assailed resolution and order effectively integrated an action to compel recognition with an action for support, such was valid and in accordance with jurisprudence. In Taig v. Ca., we allowed the integration of an action to compel recognition with an action to claim one's inheritance. Herrera v. Alba. A child born to a husband and wife during a valid marriage is presumed legitimate. Finally, physical resemblance between the putative father and child may be offered as part of evidence of paternity. DNA analysis that excludes the putative father from paternity should be conclusive proof of non-paternity. Estate of Ong v. Diaz. The new rules on DNA evidence allows the conduct of DNA testing, either motu proprio or upon application of any person who has a legal interest in the matter in litigation. The death of the petitioner does not ipso facto negate the application of DNA testing for as long as there exist appropriate biological samples of his DNA. Serposa Oy v. No Chua. It is settled, then, in law and jurisprudence, that the status and filiation of a child cannot be compromised. Being contrary to law and public policy, the compromise agreement between petitioner and respondent is void ab initio. Concepcion v. Ca. Impugning the legitimacy of a child is a strictly personal right of the husband or, in exceptional cases, his heirs. The presumption of legitimacy proceeds from the sexual union in marriage, particularly during the period of conception. Who can impugn the legitimacy of the child? Art. 170. The action to impugn the legitimacy of the child shall be brought within 1 year from the knowledge of the birth or its recording in the civil register, if the husband or, in a proper case, any of his heirs, should reside in the city or municipality where the birth took place or was recorded. If the husband or, in his default, all of his heirs do not reside at the place of birth as defined in the first paragraph or where it was recorded, the period shall be 2 years if they should reside in the Philippines, and 3 years if abroad. If the birth of the child has been concealed from or was unknown to the husband or his heirs, the period shall be counted from the discovery or knowledge of the birth of the child or of the fact of registration of said birth, whichever is earlier. Case laws. Liao v. Liao. It is settled that the legitimacy of the child can be impugned only in a direct action brought for that purpose, by the proper parties and within the period limited by law. Babiera v. Catotal. A birth certificate may be ordered cancelled upon adequate proof that it is fictitious. Thus, void is a certificate which shows that the mother was already 54 years old at the time of the child's birth and which was signed neither. Illegitimate children. All children conceived and born outside a valid marriage are illegitimate, unless the law itself gives them legitimate status. Proof of filiation of illegitimate children. Art. 175. Illegitimate children may establish their illegitimate filiation in the same way and on the same evidence as legitimate children. The action must be brought within the same period specified in Article 173, except when the action is based on the second paragraph of Article 172, in which case the action may be brought during the lifetime of the alleged parent. Notes. In other words, they can also rely on record of birth, final judgment or admission in a public document or private handwritten instrument signed by their parents, or they can also rely on an open and continuous possession of the status of an illegitimate child or by other means allowed by the rules of court. But with regards to the last two, open continuous and other means allowed by the rules, like entries in the family Bible, declaration about pedigree or scientific evidence such as DNA, they can only be invoked during the lifetime of the putative parent and not by the supposed heir. Tayag v. Ca. In Paulino, we held that an illegitimate child, to be entitled to support and successional rights from the putative or presumed parent, must prove his filiation to the latter. We also said that it is necessary to allege in the complaint that the putative father had acknowledged and recognized the illegitimate child because such acknowledgement is essential to and is the basis of the right to inherit. Potenciano v. Reynoso. The due recognition of an illegitimate child in a record of birth, a will, a statement before a court of record, or in any authentic writing is, in itself, a consummated act of acknowledgement of the child, and no further court action is required. Under the family code, filiation may likewise be established by holographic as well as notarial wills, except that they no longer need to be probated or to be strictly in conformity with the formalities thereof for purposes of establishing filiation. Abella v. Cabinero. When filiation is beyond question, support follows as a matter of obligation. To establish filiation, an action for compulsory recognition may be filed against the putative father ahead of an action for support. In the alternative, an action for support may be directly filed, where the matter of filiation shall be integrated and resolved. Art 176. Illegitimate children shall use the surname and shall be under the parental authority of their mother, and shall be entitled to support in conformity with this code. However, illegitimate children may use the surname of their father if their filiation has been expressly recognized by the father. 1. Through the record of birth appearing in the civil register, or 2. When an admission in a public document, or 3. Private handwritten instrument is made by the father. Provided, the father has the right to institute an action before the regular courts to prove non-filiation during his lifetime. Grande v. Antonio 2014 and Bank. The general rule is that an illegitimate child shall use the surname of his or her mother. The exception provided by RA 9255 is, in case his or her filiation is expressly recognized by the father through the record of birth appearing in the civil register or when an admission in a public document or private handwritten instrument is made by the father. In such a situation, the illegitimate child may use the surname of the father. Other rights. 1. Support. Illegitimate children are likewise entitled to support from their parents. However, only the separate property of the person obliged to offer support shall be answerable. 2. Succession. Illegitimate children also are compulsory and legal heirs, with reference to their parents. Art 171. The heirs of the husband may impugn the filiation of the child within the period prescribed in the preceding article only in the following cases. 1. If the husband should die before the expiration of the period fixed for bringing his action. 2. If he should die after the filing of the complaint without having desisted therefrom, or 3. If the child was born after the death of the husband. Note, the mother of the child is not permitted to impugn the legitimacy of her own child even if she may have been sentenced as an adulteress. Legitimated children. Who may be legitimated? Art 177. Children conceived and born outside of wedlock of parents who, at the time of conception of the former, were not disqualified by any impediment to marry each other, or were so disqualified only because either or both of them were below 18 years of age, may be legitimated. As amended by RA number 9858. How legitimation takes place? Art 178. Legitimation shall take place by a subsequent valid marriage between parents. The annulment of a voidable marriage shall not affect the legitimation. Requisites. 1. The child was born and conceived outside of wedlock. 2. The parents do not suffer any legal impediments, aside from minority, to marry each other at the time of the conception of the child. 3. The parents subsequently enter into a valid marriage. Abadilla v. Tubilaran. Despite his subsequent marriage to Priscilla, these 3 children cannot be legitimated nor in any way be considered legitimate since at the time they were born, there was an existing valid marriage between respondent and his first wife. Effects of legitimation. Art 180. The effects of legitimation shall retroact to the time of the child's birth. Posthumous legitimation. Art 181. The legitimation of children who died before the celebration of the marriage shall benefit their descendants. Adopted children. Adoption refers to the socio-legal process of providing a permanent family to a child whose parents had voluntarily or involuntarily given up their parental rights, permanently transferring all rights and responsibilities, along with filiation, making the child a legitimate child of the adoptive parents. Jurisdiction, National Authority for Child Care, NACC. It is administrative in nature. Domestic Administrative Adoption and Alternative Child Care Act, RA 11642. The National Authority for Child Care, NACC, shall exercise all powers and functions relating to a. Alternative child care including b. Declaring a child legally available for both domestic administrative adoption and intercountry adoption. c. Foster care. d. Kinship care. E. Family-like care, or who may adopt. SEC 21. The following may adopt. A. Any Filipino citizen at least 25 years of age who 1. Is in possession of full civil capacity and legal rights. 2. Has not been convicted of any crime involving moral turpitude. 3. Is of good moral character and can model the same. 4. Is emotionally and psychologically capable of caring for children. 6. Is in a position to support and care for adopted children in keeping with the means of the family. Provided that the requirement of 16-year difference between the age of the adopter and the adoptee may be waived when the adopter A. Is the biological parent of the adoptee, or B. Is the spouse of the adoptee's parent. B. The legal guardian with respect to the ward after the termination of the guardianship and clearance of financial accountabilities. C. The foster parent with respect to the foster child. Foster care refers to the provision of planned temporary substitute parental care to a child by a foster parent. D. Philippine government officials and employees deployed or stationed abroad, provided that they are able to bring the child with them, and E. Foreign nationals who are permanent or habitual residents of the Philippines for at least 5 years possessing the same qualifications as above stated for Filipino nationals prior to the filing of the petition, provided that they come from a country with diplomatic relations with the Republic of the Philippines and that the laws of the adopter's country will acknowledge the certificate of adoption as valid, acknowledge the child as a legal child of the adopters, and allow entry of the child into such country as an adoptee, provided, further, that requirements of residency may be waived for the following. 1. A former Filipino citizen, habitually residing in the Philippines, who seeks to adopt a relative within the fourth civil degree of consanguinity or affinity, or 2. One who seeks to adopt the legitimate child of the Filipino spouse, or 3. One who is married to a Filipino citizen and seeks to adopt jointly with the spouse a relative within the fourth degree of consanguinity or affinity of the Filipino spouse. Spouses shall jointly adopt, except in the following cases. A. If one spouse seeks to adopt the legitimate child of the other, or B. If one spouse seeks to adopt own illegitimate child, provided that the other spouse has signified consent thereto, or C. If the spouses are legally separated from each other. Who may be adopted? Section 22. The following may be adopted. A. Any child who has been issued a certificate. B. The legitimate child of one spouse by the other spouse. D. A Filipino of legal age if, prior to the adoption, said person has been consistently considered and treated by the adopters as their own child for a period of at least 3 years. E. A foster child. F. A child whose adoption has been previously rescinded. G. A child whose biological or adoptive parents have died, provided that no proceedings shall be initiated within 6 months from the time of death of said parents, or H. A relative of the adopter. Effects of a decree of adoption. Art. 189. Adoption shall have the following effects. 1. For civil purposes, the adopted shall be deemed to be a legitimate child of the adopters, and both shall acquire the reciprocal rights and obligations arising from the relationship of parent and child, including the right of the adopted to use the surname of the adopters. 3. The adopted shall remain an intestate heir of his parents and other blood relatives. Art. 190. Legal or intestate succession to the estate of the adopted shall be governed by the following rules. 1. Legitimate and illegitimate children and descendants and the surviving spouse of the adopted shall inherit from the adopted, in accordance with the ordinary rules of legal or intestate succession. 3. When the surviving spouse or the illegitimate children of the adopted concur with the adopters, they shall divide the entire estate in equal shares, 1/2 to be inherited by the spouse or the illegitimate children of the adopted and the other half by the adopters. 4. When the adopters concur with the illegitimate children and the surviving spouse of the adopted, they shall divide the entire estate in equal shares, 1/3 to be inherited by the illegitimate children, 1/3 by the surviving spouse, and 1/3 by the adopters. 5. When only the adopters survive, they shall inherit the entire estate, and 6. When only collateral blood relatives of the adopted survive, then the ordinary rules of legal or intestate succession shall apply. A. Support. Support comprises A. Sustenance, B. Dwelling, C. Clothing, D. Medical attendance, E. Education, F. Transportation. Note, the right to support is purely a personal right essential to the life of the recipient. So it cannot be subject to attachment or execution. Support cannot be an object of contract. Art 195. 1. The spouses. 2. Legitimate ascendants and descendants. 3. Parents and their legitimate children and the legitimate and illegitimate children of the latter. 4. Parents and their illegitimate children and the legitimate and illegitimate children of the latter, and 5. Legitimate brothers and sisters. Art 196. Brothers and sisters not legitimately related, whether of the full or half-blood, are likewise bound to support each other to the full extent set forth in Article 194, except only when the need for support of the brother or sister, being of age, is due to a cause imputable to the claimant's fault or negligence. Source of support. Art 197. In case of legitimate ascendants, descendants, whether legitimate or illegitimate, and brothers and sisters, whether legitimately or illegitimately related, only the separate property of the person obliged to give support shall be answerable, provided that in case the obligor has no separate property, the absolute community or the conjugal partnership, if financially capable, shall advance the support, which shall be deducted from the share of the spouse obliged upon the liquidation of the absolute community or of the conjugal partnership. Parental Authority. Medina v. Makabali. The right of parents to the company and custody of their children is but ancillary to the proper discharge of parental duties to provide the children with adequate support, education, moral, intellectual and civic training and development. While our law recognizes the right of a parent to the custody of her child, courts must not lose sight of the basic principle that, in all questions of the care, custody, education and property of children, the latter's welfare shall be paramount, and that for compelling reasons, even a child under 7 may be ordered separated from the mother. Sagolades Leo v. Ca. In the instant petition, when private respondent entrusted the custody of her minor child to the petitioner, what she gave to the latter was merely temporary custody, and it did not constitute abandonment or renunciation of parental authority. For the right attached to parental authority, being purely personal, the law allows a waiver of parental authority only in cases of adoption, guardianship and surrender to a children's home or an orphan institution which do not appear in the case at bar. Santos v. Ca. Parental authority and responsibility are inalienable and may not be transferred or renounced except in cases authorized by law. Renunciation. Art 210. Parental authority and responsibility may not be renounced or transferred except in cases authorized by law. Silis v. Kafur. The word entrusted cannot convey the idea of definite and permanent renunciation of the mother's custody of her child. Guardianship is always or almost invariably understood to be temporary. While one is a minor or is incompetent, a guardian is appointed, but when minority has passed or incapacity has ceased, guardianship also terminates. Joint exercise of parental authority. Art 211. The father and the mother shall jointly exercise parental authority over the persons of their common children. In case of disagreement, the father's decision shall prevail, unless there is a judicial order to the contrary. Art 213. In case of separation of the parents, parental authority shall be exercised by the parent designated by the court. 1. In case of disagreement, the court will decide who between the parents will have custody. 2. Basic rule is if the child is below 7 years old, he should be with the mother. If over 7 years old, the child will decide. 3. Best interest and welfare of the child rule. Hirsch v. CA. The so-called tender age presumption under Article 213 of the Family Code may be overcome only by compelling evidence of the mother's unfitness. Here, the mother was not shown to be unsuitable or grossly incapable of caring for her minor child. All told, no compelling reason has been adduced to wrench the child from the mother's custody. Beckett v. Sarmiento, Jr. 2013. The matter of custody, to borrow from Espiritu v. Court of Appeals, is not permanent and unalterable and can always be re-examined and adjusted. The preference of a child over 7 years of age as to whom he desired to live with shall be respected. Moreover, custody, even if previously granted by a competent court in favor of a parent, is not, to reiterate, permanent. Dacassin v. Del Mundo Dacassin. Separated from the mother. Clearly then, the agreement's object to establish a post-divorce joint custody regime between respondent and petitioner over their child. Chua v. Cabangbang. The absence of any kinship between the child and the Cabangbangs alone cannot serve to bar the lower court from awarding her custody to them. Indeed, the law provides that in certain cases the custody of a child may be awarded even to strangers, as against either the father or the mother or against both. Tender age rule: children 7 years old and below should be under the custody of the mother. Except for compelling reasons. 1. Abandonment. 2. Unemployment and immorality. 3. Habitual drunkenness. 4. Drug addiction. 5. Maltreatment of the child. 6. Insanity. 7. Affliction with a communicable disease. The court decides whether there are compelling reasons. Case laws. If a child is under 7 years of age, the law presumes that the mother is the best custodian. The presumption is strong, but it is not conclusive. It can be overcome by compelling reasons. Child who is exposed in the open immorality of the parent even in such tender years would most likely not result in an upright or open-minded individual and thus enough ground for depriving the parent of custody even if the child is of tender years. Substitute parental authority. Art. 216. In default of parents or a judicially appointed guardian, the following person shall exercise substitute parental authority over the child in the order indicated. 1. The surviving grandparent, as provided in Art. 214. 2. The oldest brother or sister, over 21 years of age, unless unfit or disqualified, and 3. The child's actual custodian, over 21 years of age, unless unfit or disqualified. Whenever the appointment or a judicial guardian over the property of the child becomes necessary, the same order of preference shall be observed. Lual Santos v. CA, limited to these 3 instances, so only in case of parent's death, absence or unsuitability may substitute parental authority be exercised by the surviving grandparent. Special parental authority. Art. 218. The school, its administrators and teachers, or the individual, entity or institution engaged in child care shall have special parental authority and responsibility over the minor child while under their supervision, instruction or custody. Authority and responsibility shall apply to all authorized activities whether inside or outside the premises of the school, entity or institution. Extent of liability of those exercising special parental authority. Art. 219. States that they shall be principally and solidarily liable for damages caused by the acts or omissions of the unemancipated minor. The parents, judicial guardians or the persons exercising substitute parental authority over said minor shall be subsidiarily liable. What are the available defenses for them? That they exercise the proper diligence required. Amadora v. CA. Unlike the parent, who will be liable only if his child is still a minor, the teacher is held answerable by the law for the act of the student under him regardless of the student's age. PSBA v. CA. When an academic institution accepts students for enrollment, there is established a contract between them, resulting in bilateral obligations which both parties are bound to comply with. The school may still avoid liability by proving that the breach of its contractual obligation to the students was not due to its negligence. Effects of parental authority. Art 221. Parents and other persons exercising parental authority shall be civilly liable for the injuries and damages caused by the acts or omissions of their unemancipated children living in their company and under their parental authority, subject to the appropriate defenses provided by law. Defense of the parents. Libby v. IAC. Parents are and should be held primarily liable for the civil liability arising from criminal offenses committed by their minor children under their legal authority or control, or who live in their company, unless it is proven that the former acted with the diligence of a good father of a family to prevent such damages. St. Mary's Academy v. Carpetanos. For petitioner to be liable, there must be a finding that the act or omission considered as negligent was the proximate cause of the injury caused, because the negligence must have a causal connection to the accident. Thank you for watching. Next video is about property under the Civil Code of the Philippines. Subscribe to my channel for more updates. Thank you.